As we settle into the new year, all New York and California employers should be aware of some changes that prohibit employers from requiring employees to repay certain amounts in the event they leave employment prior to a set date. These are commonly known as stay or pay agreements. Both New York and California recently enacted laws regulating these types of agreements, though the laws currently differ in key ways. First, let's turn to New York. Effective as of December 19, 2025, New York's law, known as the Trapped at Work Act, prohibits employers from requiring, as a condition of employment for any current or prospective worker, such worker to execute an employment promissory note. The Act defines an employment promissory note as any instrument, agreement, or contract provision that requires a worker to pay the employer or the employer's agent or assignee a sum of money if the worker leaves such employment before the passage of a stated period of time. While the definition of employment promissory note is very broad, it is clear that the law prohibits agreements requiring employees to repay costs associated with training. The law also contains a number of exclusions. The following types of agreements remain permissible. 1. Repaying money advanced by an employer unless the money was used to pay for training related to the worker's employment. 2. Paying an employer for any property it has sold or leased to the worker. 3. Requiring educational personnel, such as professors, to comply with terms or conditions of sabbatical leaves. And 4. Any program agreed to by an employer and its workers' collective bargaining representative. The law is silent with respect to common types of agreements requiring repayment, such as sign-on bonuses, relocation stipends, and other similar incentives. While these types of agreements will likely remain permissible, the Department of Labor may issue clarifying guidance on this issue. It is also unclear whether the law only applies to contracts entered into after the effective date of December 19, 2025, or whether it invalidates offending provisions in existing agreements as well. In any event, New York employers should ensure that any stay or pay agreements they attempt to enforce are permissible under the Act. Should an employer sue a worker to enforce a stay or pay agreement that is prohibited under the Act, the worker is entitled to recover attorney fees, and New York employers who violate the Act are also subject to fines between $1,000 and $5,000 for each violation. However, there is no standalone private right of action. Employers should also be aware that on January 6, 2026, the New York State Assembly introduced proposed amendments to the Trapped at Work Act. These amendments are intended to address ambiguities in the law and respond to concerns raised by Governor Hochul. The amendments would delay the Act's effective date to December 19, 2026, narrow its scope to employees only, and clarify permissible repayment arrangements, including certain bonuses, relocation assistance, and limited tuition repayment agreements for transferable credentials. Many of these proposed amendments would bring the law more in line with California's newly enacted law, which we'll discuss shortly. Although these amendments have yet to be enacted, employers should be aware of these potential changes when considering entering into agreements with employees. However, in the meantime, the current version of the law remains in effect.
California's newly enacted Assembly Bill 692, which took effect on January 1, 2026, prohibits employers from requiring workers to sign employment or work-related contracts that financially penalize them for leaving a job. Specifically, employers are prohibited from including in any employment or work-related contract provisions that, upon termination, 1. Require a worker to repay a debt to the employer, a training provider, or debt collector. 2. Initiate or resume debt collection activities or end a period of forbearance. Or 3. Impose any penalty, fee, or cost on the worker. Similar to New York's stay or pay law, there are a number of circumstances where AB 692 permits repayment provisions in employment contracts. First, employers may require repayment of certain upfront discretionary payments, such as signing bonuses, retention bonuses, or relocation stipends, so long as strict rules are followed. The repayment terms must be in a separate agreement, workers must be given time to consult an attorney, and any repayment must be interest-free and prorated over the period of time during which the employee would have a repayment obligation, but which may not exceed 2 years from the receipt of payment. Employers can seek repayment only if the worker leaves voluntarily or is terminated for misconduct. For a retention or signing bonus, the employee must also be given the option to wait to receive the payment until it would have been considered earned and no repayment would be due. Second, AB 692 allows repayment of tuition costs for transferable education credentials as long as the credential is not required for the job, the agreement is separate from the employment contract, the amount is limited to the employer's actual cost, and repayment is prorated. Workers generally do not have to repay these costs if they are terminated by the employer unless the termination is for misconduct. Other permitted repayment provisions and agreements include 1. Loan repayment assistance or forgiveness programs provided by a federal, state, or local governmental agency. 2. Contracts related to enrollment in any apprenticeship program approved by the Division of Apprenticeship Standards. And 3. Contracts relating to the lease, financing, or purchase of residential property. Unlike New York's law, AB 692 creates a private right of action, allowing affected workers or worker representatives to bring claims on behalf of that worker, other persons similarly situated, or both. Minimum damages in the amount of $5,000 are available per affected worker, in addition to injunctive relief and recovery of attorney's fees or costs. Notably, AB 692 is not retroactive and applies only to contracts entered into on or after January 1st, 2026. In light of these legal changes, all New York and California employers should review any agreements with employees to ensure compliance with these laws. In particular, California employers should ensure that sign-on bonus terms and tuition repayment provisions are in standalone agreements and meet AB 692's conditions. Employers should also continue to monitor their proposed amendments to New York's law. For more information, please contact a member of our team, and please refer to Aiken's client alert discussing AB 692 in more detail, which we will link in this post.